Hello, people of the internet. My name is Connor Wicknick. I'm a family law attorney here at Beresford booth. And today I want to be presenting about, or I will be presenting about, anti-harassment protection orders. My practice area includes issues related to divorce, parenting plans, child support, committed intimate relationships, and of course these protection orders, which oftentimes are intertwined with all those different types of family law matters. As a caveat before I get started, while domestic violence protection order statutes are uniform throughout the state, there might be different processes based on the county that you're in for obtaining a protection order. And so it's always recommended that you speak with an attorney or contact your local courthouse protection order office to figure out the processes that need to happen in order for you to gain a protection order, as well as to get advice on how to go about doing that, as well as strength of case arguments, etc. It also goes without saying that if you believe you're in immediate danger right now of domestic violence, stop watching the webinar, skip the rest of it, contact your local law enforcement. I'm not going to be able to help you by watching, or you're not going to be able to help yourself by watching the webinar. It's better for law enforcement to handle that. So I'm going to cover a couple topics today. And I'm going to be doing just a very general, basic view of these anti-harassment protection orders. The first question we're going to be addressing is, what is an anti-harassment protection order? Second question is, why would you need one? Third is, how do you get one? How do I get one? And fourth is, how will it protect me? This presentation is about one type of protection order. As you're going to see, when people call in and they say, I need a protection order or a restraining order, there's actually quite a few different types that may apply in a given circumstance. And so I'm going to talk about those briefly on this next slide. So the counties that I practice in, King and Snohomish County, have different protection orders listed on their website. A couple of these are domestic violence protection orders, with kind of this umbrella that they all live under. There's extreme risk protection orders, which often have to do with people with firearms, or when there's a need for a temporary protection order to be put in place immediately and without notice to the other party. Of course, there's sexual assault protection orders, which have to deal with specifically sexual assault. There's stalking protection orders, which might intertwine a little bit with anti-harassment, but are their own sort of thing. There's also vulnerable adult protection orders for people who are elderly or unable to help themselves, either get a protection order or maybe not be an advocate for themselves. Just so you know, when you're deciding whether or not a protection order might be needed in your case, or you're feeling like you want to get a protection order, when you file a petition for a protection order, the court, per statute, can't dismiss or deny your petition based on you filing for one of these type of protection orders that might not be the right fit. In fact, the court makes a determination as to which might apply most in your case and will enter it as such. Additionally, if you file in the wrong court, the court has the responsibility of entering findings or establishing what court you need to be in, and will direct the clerk to transfer that petition to the correct court. These are changes that have happened recently in the law, just to make sure that people are receiving the help they need, and they aren't being turned away based on confusion around what they're asking for or where they need to be filing, which is an overall good thing. So the big question is, what is an anti-harassment protection order? So defined as, or it's a protection order that serves a purpose to protect against unwanted contact or behavior that causes the person who's filing the protection order to feel substantial emotional distress, and it serves no legitimate or lawful purpose. there's a kind of a subsection here that says the contact could be a pattern of behavior that occurs over time or a single act or threat of violence. The contact must be directed specifically at the protected person who's filing for the protection order, and it must be seriously alarming, annoying, harassing, and detrimental. Know that when you're petitioning the court for a protection order, this is the framework that they're dealing in, and they're going to be kind of working through this like a checklist. They're seeing, is the person who's filing the protective order receiving some sort of unwanted contact or behavior? And I'll kind of go into that on this next slide of what that might be. Are they feeling emotional distress? This can be demonstrated. A lot of time people share how they're feeling around this, which is a big component of commissioner's decision or judge's decision as to whether to issue a protection order. The other thing is whether the communication that this person is receiving or contact or behavior, it serves no legitimate or lawful purpose. And we'll kind of get into that as well. Just so you know, internet audience, unlawful harassment under the statutes in Washington. I'm going to read through it really quick to give a little bit more context. It's a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person that serves no legitimate or lawful purpose. The course of conduct must be such that would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the petitioner or person who's asking for the protection order. It goes on to say a single act of violence or threat of violence directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, and that would serve no legitimate or lawful purpose, which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress to the person asking for the protection order. There's an interesting little part here that says a single threat of violence must include either a malicious intentional threat as described under RC W9A 36080, or has the presence of a firearm or other weapon involved. The first point, that statute, the RCW 9836080, is actually the Washington's hate crime statute. So if you are interested in looking up the specific language for that, it ties in so that you can get an anti-harassment protection order if there's an instance of a hate crime against you, which is one of these great benefits, one of these great protections that these type of orders provide. So why might you need one? Well, to protect yourself from harassment. Kind of give a general overview. Harassment can happen online or in person, through email, through phone calls and text. This is a type of harassment that I've been seeing a lot with my clients, especially through texts and emails, and even through social media and things like that. I don't want to say the benefit, but when this type of harassment is happening online, or there's a written record of this type of harassment, it often makes the case easier to petition for, in the sense that you're able to demonstrate, this is the harassment I'm experiencing, this is the language the person's using, to harass me, or this is the course of conduct that they're doing. What comes to mind is, phone calls at 2 o'clock in the morning, repeated emails without response, especially when the petitioner, the person who's asking for the protection order, has told the other person, please do not contact me. It's one of those things that, again, this type of protection order can help stop. It goes without saying that harassment in any form can have severe implications for one's mental health, emotions, and feelings of safety. This goes to that substantial emotional distress factor is people go through when their daily patterns and things they need to do on a daily basis are interrupted because, I guess, going to the second point, that harassment can be unpredictable and disrupt their day. People can suffer immensely and experience immense stress at the hands of their harassers. kind of tied into this is that harassment can be part of domestic violence, kind of as a general or global concept, and can fit also under the coercive control part of the domestic violence statute. That deserves its own webinar. I'm not going to talk about that today, but harassment often, when we see it, goes hand in hand with other types of domestic violence, or can be used in a way that kind of perpetuates other types of domestic violence. Again, luckily in Washington, if you aren't sure what type of domestic violence you're experiencing, you're able to file this petition, get the protection you need, and at some point the court's going to say, hey, this is harassment. This is the best kind of served, or this will be best served with an anti-harassment protection order as opposed to a stalking protection order or something like that. Before I move on to the next slide, that third kind of prong of the analysis, the context that petitioner is experiencing must be, or it must be seriously alarming, annoying, harassing, detrimental. This kind of goes into that emotional time of emotional distress. But just know that, especially if you're feeling like it is alarming, annoying, detrimental to you in any way, that's something that you can use to in your petition for a protection order of this type. So this next slide is, how do I get an anti-harassment protection order? It's contact your local attorney or staff in the protection order office at your local courthouse. Often, they're able to analyze whether or not an harassment protection order is needed. Again, this is something you're going to feel and know that you want to petition for, but they might be able to kind of fit it into one of those boxes of what type of domestic violence you're experiencing and whether or not this specific type of protection order is what you're looking for. When you go to the courthouse, there will be forms, or when you talk to an attorney, there will be forms that need to be filled out and filed with the court. There's going to be the petition for the protection order, a declaration, which is actually your written statement about what type of harassment you're experiencing. The declaration also includes exhibits, so a lot of times I'll have clients attach text threads or email threads to their declaration to show what they're alleging is actually happening, and kind of the details of that type of harassment. And it helps give more context for the judge or commissioner to use in their decision as to whether to grant a protection order overall. Another one of those forms is the law enforcement confidential information form. This is filled out and given, submitted to the court so that law enforcement in your area knows that this is going on. They know who to look for if you need to call in for their assistance. And it also gives some information about you to kind of, again, put them on notice or say, hey, there's an active case where there's harassment going on. There's a protection order that's been issued and a person calling in. It's kind of the fast track of details that they would need in order to stop that type of harassment or give you some sort of protection. Another form is the temporary protection order and hearing notice. Temporary protection order, again, could deserve its own webinar, but a temporary protection order is when there's an immediate need for a protection order to be entered. You can actually do so at initial filing without notice to the other party, typically. That gives you a protection order for 14 days or until a return hearing is set, which I'll talk about in a second here. And a lot of times people want to fill out that form and submit it as well as the petition and other forms to get the process started, especially if they're feeling like they're at a boiling point and need that help immediately. Another type of form is the order to surrender weapons. This goes hand in hand with the temporary protection order and hearing notice. If there's an immediate threat of weapons or there's feeling of lack of safety around someone's harasser or abuser having weapons, this is another form that can be filled out so that local law enforcement can go and have that person surrender their weapons. Again, big topic, but just something to be aware of, one of the options out there for you. And then, of course, the protection order itself, which there's the petition for protection order, and then there's actually the protection order. In between that time is when you have the hearing and all these substantive findings are being made. But know that the protection order is the official or final form that's filled out that actually grants the protection you need. And typically that's for a year, and it outlines what types of behaviors are restricted, and gives details about what the judge found and what is going to be applied in the case, or what officers can do in regard to giving you protection. So this Snohomish County website says that forms can take between 2 and 6 hours to complete, and recommends getting child care if you need it. I put this on there just as, I don't know, just kind of normalizes that the urgency of getting a protection order is great. And people, a lot of times say, hey, why can't I get this done in an hour? Why can't we just get it done right now? And it takes quite a bit of time to fill out all these forms. And so when you're going into that process, keep that in mind. The child care, of course, is if you have a kiddo with you, make sure you have some care for them while you're working with either a protection order officer at the courthouse or an attorney to get these forms filled out in the quickest way possible. Once the appropriate forms are filed, the court will schedule a hearing, kind of like what I mentioned above, typically 14 days out from the date of filing, to determine whether a final protection order is needed. As I mentioned before, the standard is that a protection order is granted for a year, though it can go longer with some sort of basis or reasoning behind that. And once that year is done, you can actually renew it multiple times. And so if you're still experiencing harassment, or feeling like you might experience harassment after the order expires in a year, you can get it renewed for your benefit. So how will the anti-harassment protection order protect me? It's the main thing is that having a piece of paper, a protection order in your hand, it lets the respondent, or the person who is harassing you or otherwise committing domestic violence against you, lets them know that, hey, you're serious about this. I want you to stop. I don't want you to continue these behaviors. And in fact, if you do continue these behaviors, I'll involve the police. And so having a protection order in place, kind of like what I mentioned before with the confidential information form, the police are put on notice. They know that this dynamic is happening, and they're able to help you in a more swift way should you need immediate help. The protection order also makes violating its terms, which can be no contact, it can be a stay away, it can be no stalking, no harm, all these things. If any of those terms are violated, it's a crime, and you can report it to your local law enforcement. Respondents 18 years or older may be arrested and face criminal charges, including jail time. Respondents under 18 who are committing these type of offenses may be held in contempt for willful disobedience, and dealt with according to the terms of the order. If the respondent, the person you filed this protection order against, contacts you, threatens you, violates the order, best thing to do is call 911, get them to enforce the order. That's what it's there for. That's why you got this protection order in the first place. Final slide, of course, again, my name is Connor Wicknick. I work here at Beresford booth as a family law attorney. If you have any questions, reach out to us. Again, as a caveat, all domestic violence protection orders statutes are uniform throughout the state. The process can be different between counties for obtaining one. It's highly recommended that you speak with an attorney that practices in your county, or with the protection order office in your respective local courthouse. And then it goes without saying, but if you're feeling an immediate danger at this moment while you're watching this webinar, get online with local law enforcement. Turn this off and start your petition process. These are stressful events, but know that there's help out there for you. And again, here at Beresford booth, we're happy to answer any questions you have. Thank you so much.